Antoinette Warren, and I am CEO and founder of Warren Publishing Group, which is a senior advocacy alliance. And we are celebrating 9 years of successful advocacy. And that's called a blessing. I'd like to start off saying that we are absolutely on fire to stop the atrocity of elder abuse. Here in Alameda County in 2019, 70% of the reports of elder abuse were financial in nature. We really have to make sure that people are aware of elder abuse by educating the community to make to place a stop on this elder abuse. So, this is the reason that we've been joined together since August. I'd like to take a couple of minutes and thank our co-presenters, which is Alameda County Care Alliance. I'm not sure if someone has joined us who is representing the alliance today. And the other presenter is the National Coalition of 100 Black Women, the San Francisco chapter. And I see that our president, Maxine Hickman, is with us this evening. Welcome, Madam President. So, since August, what we've been doing is presenting different sessions. We've had a session on the effects and prevention of elder abuse, which was in August. September, we had a session on elder abuse prevention training presented by Alameda County Adult Protective Services. And for the month of October, we had financial abuse versus estate planning, and that was October the 21st. And now today, we are having session number 4, and we're going to have demonstration on the ease and simplicity of setting up your personal will and living trust. I'd like to present my friend Jorick Gaines, who will be our presenter this evening. And Jorick has over 35 years financial industry experience and has a holistic one-stop approach to working with small business owners and families from every income level. He holds insurance licenses, life and health and property and casualty in multiple states and is a nationally registered investment advisor representative. George was also our presenter on October the 21st. He has lots of great information to share. And a few housekeeping notes. If you have questions along the way, you can put your questions in the chat. And also, if you would like to reach Mr. Gaines after this session, his number is going to be in the chat as well. And I think he's going to show the information during his presentation. So I think I've covered everything I should be covering. I'm really grateful and thankful that all of you are here. Please receive what you need and share it with other people. And Warren Publishing Group, we are bound to make sure that there is an end to this atrocity of elder abuse. Thank you. All yours, George.
Thank you, Antoinette, and thanks everybody for attending. It's great to see you've got a great audience this evening. We even have K9 joining us this evening, I see. Anyway, welcome everybody. Um, as Antoinette said, I'm a financial educator and financial advisor, and our mission is to stamp out financial illiteracy and to teach people how money really works so that they can make decisions, better decisions going forward. So, but tonight we're going to be talking about, as Antoinette said, living wills and living trust, because I have seen in my, whew, I'm going to date myself here, but in my 30 years of being in the industry as well as state, I've just seen people work all their lives to accumulate assets and not have an exit strategy. And when they make their transition to the next life, whatever you believe that is, they leave a mess behind. And not to mention that if you don't take care of that early on, then you are subject to elder abuse because you don't have your assets protected. And sometimes it's not from somebody you don't know. Sometimes it's from somebody you do know, love, and trust, only because the statement I like to say to everyone: money changes people. It changes what they think and what they do, unfortunately. And too many times I've heard families say, well, I'm talking to a parent or a grandparent, and they say, oh, well, I don't need to worry about that. We're a real close family. We'll work together and get it all figured out. And nothing could be further from the truth. Families fight, they argue. I mean, I grew up I shared a bedroom with my brother, and we couldn't decide who's going to clean the room up. What's the chances you think we're going to decide where the money goes and how this goes, and even sometimes how we put everything, which, and I'm going on a little bit. This is a real passionate area for me because I've seen it happen way too many times. So I'm going to start with a short video. It's right at 10 minutes. And then I'm going to come back and we're going to go through a will. We can't do a trust because trusts are complex. I won't say complex, but it's different. It's like a thumbprint. It's different for each one of us. Each one of us has different assets. We have different family structure. We have different concerns. We have different things we want to leave to different people, and no two are alike. So that's why if you ever go online and find a template for a living trust, avoid it, because it can't be a template, because if that means everybody's situation is the same, then that's not true. So financially, I do everything. I'm not here to sell. I'm an advisor. So whether that's insurance or retirement or debt, or matter of fact, tomorrow I'd like to extend an invitation, Antoinette, if you don't mind. I'm doing a webinar tomorrow evening. I'm hosting it, actually. I'm not the presenter, for people that have student loan debt, which is a big problem. Student loan debt is almost $1.5 trillion owed to the government in student loans. And it's some of the worst interest you ever want to deal with. So feel free to contact me afterwards and get that. I'm going to start the video, hold your questions, or you can put them in the chat. We have a moderator, if you will, that'll take those questions and we'll get to them, I promise you. So we should be done on schedule. It's scheduled for 45 minutes. We should have about 15 minutes for question and answers after that. So without any further delay or ado, as they say, I am going to share a screen with you and start this video. Antoinette, I want to apologize. What I should have done was do a little sound check on the video before. So what I'm going to do is the first couple minutes, make sure everybody can hear it, come back, do a check-in, and if I need to make some adjustments, and I didn't think to do that at first. So here we go. So let me give a little intro on this. The guy that's going to be presenting this, his name is Glenn Wagstaff. He's the managing attorney for the Legacy Shield Professional Network of over 100 attorneys nationwide. Not everybody should do that. They have a digital platform, but not everybody wants to do it digitally. For those that don't, they can do it if they need a trust. We'll get into that in a minute. He's going to explain why and when you need one. And let me give a little disclaimer. I am an advisor, insurance broker, real estate broker, and on, but I am not an attorney. I am not allowed to give legal advice. So this is just an information presentation. This is for just for your learning. If you have a situation, again, I cannot give legal advice. We need to consult with your legal advisor, or I can get you with this attorney network, and we get a special, really good price for our clients. So, you know, trust can vary depending on the attorney and what he feels his services is worth. So I won't quote what they charge, but you can get a trust generally from an attorney from anywhere from $2,000 and up, depending on the complexity of your estate, if you need a living trust. And again, that's going to be explained in a minute. So let me not go any further. Let me try this. Let me do a little radio check, if you will. And okay, can you see that okay? All right, now I'm going to start the audio, and we can rewind it if need be.
Professional man. So a lot of times people will say, okay, well, I've heard of a will and I've heard of a trust, but what's the difference?
How's that coming across?
We
Good.
can hear it.
All right, very good. And if not, as oops, I went too far back. This is, let me explain this. Glenn is actually doing an agent workshop, as you can see at the bottom. But I'm not disallowed from sending it out. So if you decide you like this platform or you want to see if it's something you want to try and take on, it's not that complicated. It has artificial intelligence. But again, it's not for everybody. Not everybody's comfortable doing it on the internet. But Legacy Shield will do it. They even just announced a $50 per month. So for those people that want to use an attorney but say the budget isn't there or need a trust and they want to use the attorneys, they can actually get their services for $50 a month. Okay. And I can go into detail. You can call me on that. All right. So since we have good sound, I'm going to go right ahead with it. Here we go.
So a lot of times people will say, okay, well, I've heard of a will and I've heard of a trust, but what's the difference? Why do I need a will? Why do I need a trust? Well, what are these things? So on a very simple level, if you have a will, your will is what's called a testamentary instrument. And a testamentary instrument, you don't need to remember that, but basically what it means is that it doesn't do anything until after you die. And once you die, then what your will does is it provides instructions and it provides guidance. You want your estate divided and who you want to take care of your children and so on and so forth, right? If you don't have a will, then the state has a plan for you. If you don't have a plan for yourself, the state has a plan for you. And basically what the state's plan is that there are defaults under state law. We call that the law of intestacy, right? And that's what your estate is going to be governed by. So for example, if you have children and they're under age 18 and they would need somebody to manage their affairs or to make decisions for them or to help raise them in your absence, that person is called a guardian. You can nominate your own guardian in your documents, and generally it would be in your will or in your power of attorney that you nominate a guardian for your children. But if you don't nominate somebody, the state law says that any interested party can nominate themselves. And I don't know about you, but I have some interested parties in my family that I don't want raising my kids. Does that make sense? And so if you want to make sure that the persons that you want in charge of taking care of your children are the right people, then you would put that in writing in your will. The second thing is that, you know, it covers the distribution of your assets in your estate. And if you don't have it out under a will, then what happens is that the default law under your state would govern how those things get divided. And that may or may not be actually how you want to leave it to everybody. So for example, I have an aunt and she never has been married and she doesn't have any children. And, you know, so if she wants to leave her assets to specific individuals, maybe, you know, her siblings, she would need to specify that in a will, because otherwise everything is going to be governed under the law of intestacy from the state. And the second thing about a will is that even though your will be followed, most likely as long as it's valid, by a court, it does have to go through the probate process, because the probate process is the process by which the court will actually validate the will and make sure that it's valid. and then follow the terms of the will and make sure that that's enforced by the personal representative who's appointed. So probate is a process where you go through the court system, and sometimes that can be simplified, and sometimes it's very cumbersome. But generally speaking, it can cost a lot of money. It can take a long time. It can cause family problems very easily because you're already, right? And it's a public process, and most people want to avoid that. So if you have a will, your will doesn't do anything until after you die, and it will have to go through probate. The difference between having a proper will and having a proper trust is that a trust plan begins protecting things immediately. And the second part is that a trust doesn't have to go through probate. If it's funded properly and you have your assets in your trust, then nominate somebody known as a trustee, and that person manages your estate and manages your assets on your behalf as if you were still alive, right? And so it can avoid the probate process altogether. And that's the biggest difference between a will and a trust. So the question is, when would you need one over the other? And basically the simple answer is everybody needs to have certain documents that we call, financial power of attorney and healthcare documents, those sort of things. That's kind of the basics that everybody should have. Once you have children, or once you have significant property, and by significant property in most states, it's around 150,000 worth of value, or net worth, or real estate, because any real estate is generally going to have to go through probate if it's not titled properly or if it's not in a trust. Then that's when we recommend that you have a will. If you have both children, no matter what age they are, whether they're adults and they're all independent or whether they're still minors, and you have substantial property, then that's when you need to have a trust, right? And that's kind of the general recommendations. So trust can help you avoid probate in the case of having too much assets where you would have to go through probate, or in the case where you have real estate and that would have to go through probate to be able to transfer to the next generation or to the next individuals that you want to leave it to, unless it's properly titled or unless it's in a trust, right? And so that's what we would recommend in general. And a will plan should include your will for both you and your spouse if you're married. It should include your financial powers of attorney. And then it should include the healthcare documents as well. So a HIPAA authorization to authorize information to be left to your loved ones, a healthcare power of attorney. It could also be called a living will or healthcare directive. There's lots of names for it, but basically a document that empowers somebody to make healthcare decisions. Those are kind of the basics that you should have in your plan. And in a trust, you also will have a will, but your will is what's called a pour-over will. The pour-over will basically just puts everything into your trust in case it wasn't already in there. And so it's kind of a safety net, just in case something was left out of the trust, it'll put it into the trust. And that way you didn't have to worry about forgetting about it if you accidentally forgot to put something in there, right? You should also have your financial powers of attorney, your HIPAA authorization, and your healthcare power of attorney. We call those healthcare documents, right? And so a complete plan should include all those things. And then in order for your trust to function properly, you also will want to make sure that you actually put your assets into the trust, because it doesn't do any good to actually have your trust and then not have anything in it. So if you have bank accounts, you need to leave a beneficiary designation for those accounts to go into the trust. If you have insurance policies, you should designate beneficiary designations to have it flow through your trust. If you have investments, same thing. If you had, real estate, we would title the real estate and transfer it into the trust. And then your trust will then distribute out to whoever you decide under the terms of the trust as part of your estate. So that's kind of the basics. So at this point, what we're going to do is show you how the Legacy Shield system works.
Actually, we're not. That's the shortness of that. So what I'm going to do here is show you an example, and this is something I actually found right online at a place called Law Depot. I know nothing about Law Depot, so I'm not recommending it. Did we want to take any questions on that now, Antoinette, since we just finished that video? While it's fresh in people's mind, and then get to the filling, or should we just go through the will and then take questions? You're muted, Antoinette.
Let's see. Why don't we just move forward with that?
Okay, that's fine. Okay, so as you can see, this is a last will. Let me say one thing that people don't think about. How many of you, just by show of hands, know someone that has children still at home that are over, that their parents are still, they're still a dependent of their parents, but they're over 18 years old? How many of you know people in that situation? Do you realize, and here's one thing that parents are just shocked, if your child ends up in the hospital, say they get a car accident, and there's decisions that need to be made medically, or the doctor needs to communicate to people what's going on so that they can make decisions, do you realize you cannot make decisions for your 18 and above year old child that you are taking care of financially? Because they are of legal age. And if you don't have your HIPAA form, your medical directive for that child on file, that doctor cannot tell you the medical situation. That usually floors parents, because they go, what do you mean he can't tell me? He's an adult, she's an adult. You have to have that form in your hand or filed for him to be able to talk to you and tell you what's going on. Shocking, isn't it? Just thought I'd bring that up. Most people are just blown away when they hear that. So anyway, moving right along. This again is the last will, and we just want to show you what it takes. It's not that complicated, and it's really no sense people don't have it in place. So this is the last will and testament of your name. I, your name, presently of, I bet everybody knows what goes there, right? We've all heard it on TV. Presently of sound mind. You know, you got to be of sound mind. It used to be you could bring an attorney in on your relative deathbed and get a trust done, but they don't do that anymore. You have to be of sound mind, and it can't be a last minute type situation. There's no rule on how far it has to be, but it can't be coerced, because they'll accuse you of a coercion. Other people will, oh, she forced my mom to do that, and so on and so forth. All right. President of Oakland, California, declare that this is my last will and testament. So it basically voids out any previous wills and codicils. It describes your marital status. Of course, if you're married, you need to change this. Of course, that's why this isn't one size fits all. Parent children. The term child or children is used in this will includes the above listed children and the children of mine that are subsequently born or legally adopted. And then it goes through the executor and who you appoint as the executor of your will. So when you pass, someone has to execute what you have written, how you want to be buried, or whether you want to be cremated, where you want whatever assets you have to go, and they are the executor. No bond or security of any kind will be required of any executor appointed in this will. And then it lists the powers of the executors, what they can do, whether they can sell or trade or buy or repair, and so on and so forth. And again, this is an example. You may not agree with how this is written, which is why you have to write your own. And you can just see and again, this is it. If you want to look at this on your own in your own time, it's lawdepot.com. And this is, again, I'm not promoting this. I don't even know who this company is. I just searched it. It was one of the first things that came up on Google. It made sense. We just want to show you the ease of how it is to complete a will. And everybody should have at least a will. As you heard Glenn say in the video, If you have property in California, it may vary by state. If your gross estate, that does not count any debt, gross meaning everything you own, is worth more than $150,000, it is a state requirement that your estate be probated, which means go before the court. As he said, if you don't have a plan, the state has a plan for you. You default to the state's plan. And if you know, if it's government, no offense if anybody's in government, you know it's gonna cost you some money and there's gonna be some red tape. That's a guarantee. I can guarantee you that. All right, so here's all the, you're giving the powers to your executor, whatever powers you want to give them. Now notice this is just a simple will. It does not have, if I'm not mistaken, I looked at a couple of them. I want to make sure I got the right one, but it doesn't have the medical directives and the HIPAA form and so on and so forth. And so, and this is the disposition of the estate. Forgive me, that's a bug. I direct my executive to distribute the residents of my estate as follows. Now, again, if you have property, you can give this disposition of this instruction or allow this executor to do this. But if you own a house, it has to be probated. So, and that probate, especially right now when we're going through COVID, courthouses aren't operating as normal. So they're backlogged. A lot of the court proceedings are done online. Who knows when you're going to get in? It could take forever. That's a bit of an exaggeration, but you know what I mean. Here's the testamentary trust that he talked about, testamentary, that term. Trust administration, the trustee shall manage the testamentary trust as follows. Now, again, you could edit this based on your situation. This is really just an example. And then when the trust terminates, I've seen trusts that go on for 99 years after the last child is passed away. So you can, we like to say a living trust is controlling your wealth from your grave. You can literally distribute your assets as you see fit, even though you're no longer here. So, and I could just go on situation, you know, just about every family has unfortunately someone with drug problems or alcohol problems, and you don't want to give that person a lot of assets because they won't have it very long. So you can actually have a trust that distributes that as you see fit, even though you're not here to oversee it. You can give that power to someone else. So you can say, only give this kid what he needs for the basic living: food, clothing, and shelter, nothing extra. Within the average. So they can't go live in Black Hawk and say, well, I need that to pay my rent. You know, on average. So you can literally control that. So you have all of your general trust provisions, again, powers of the trustee, and it just goes on and on. You can do literally just about anything. It has general provisions, individuals omitted from bequest. There's some laws, and this is why you might need some legal folks, because there's some laws that say if you don't leave people that are your immediate family at least X number of value, then they can, of course, file a claim that they didn't get their fair share, and so on and so forth. No contest provision. I like this part right here. It says, if any beneficiary under this will contest in any court any of the provisions in this will, then each and all such persons shall not be entitled to any devises, legacies, bequests, or benefits under this will, or any condescend hereto. And such interest or share in my estate shall be disposed of as if that contesting beneficiary had not survived me. In other words, you take the rest of the family to court, you are disinherited. You get nothing. You can do that. It's legal. Now, of course, you have to sign it, date it, and a notary in the presence of at such and such, and these are the, well, let's see, it doesn't have to be notarized, it seems, but you have to have 2 witnesses, But I thought it does have to be notarized. Anyway, this may be, let's see, presence of tester of each. I'm not an attorney, as I said. But of course, it has to be executed. If you haven't executed it, and I always advise people to give a copy to at least 3 people. They don't necessarily have to be your family. Could be a legal advisor, could be a financial advisor, could be your bank. Put this in my safety deposit box. Now, one of the areas a lot of people make, they put stuff in their safety deposit box and then they don't give anyone else a key. That's a problem. So make sure you take care of that. And that's how simple it is to draw up a will. Now, again, if you've got 3 rental properties in the house you live in, it's a little more complicated. You've got kids and grandkids, and depending on your age, maybe great grandkids you want to leave something to, you might want to get legal advice and not try to do it on your own. As you heard Glenn talk about, Legacy Shield is a digital platform that you can actually execute on your own. If you just, it has what they call artificial intelligence. I know a lot of people are hearing that these days. That means based on how you answer the initial questions, it knows what documents you need to have in your will. You can even bequest to your dog or your dogs, plural. There are people, I have clients that have literally left money for their dog to be taken care of. I have a client that is a type 1 diabetic. She doesn't expect to live past 65. She's only 51 now, I think. But she's left money for her dog. Now, based on dog averages, that dog probably won't be here, but still, she's taking care of that step. So there's nothing you can't leave. You can leave to your church, favorite charity, whatever the case may be. Okay? But it has to be in writing. If it isn't in writing and you have witnesses that you did it, they'll throw it out of the court. The courts will throw it out. I mean, the courts can throw anything out, but that's almost an automatic. Okay? And again, you can search, and it gives you a lot of explanation. I just saw this. Can I give away all of my property in a will? Yeah, you can give away most, but not all. But this is a great place to read. So, for instance, life insurance policies, retirement plans, typically investments have beneficiaries named. There is no need to put that in a trust or a will. When you pass, that beneficiary need only to supply their identification and a copy of your death certificate to claim their inheritance or to prove that they're the beneficiary entitled to that asset. But yeah, just about every pension, well, pensions, on this note, I want to make sure people understand this. Pensions are generally only, if it's elected, go to your spouse. Your kids cannot inherit your pension. So I usually advise, depending on the situation, that if a person has a pension and they retire, depending on the pension plan and what it allows, a lot of times I recommend they roll it over if we can get them a better income stream. Because when they die, they can't pass that on to their kids. So in essence, you retire at 65, you die at 67, the company keeps the rest of your pension. A lot of people are shocked about that as well. I always like to watch people's reactions when they hear that. They go, what do you mean? I worked 35 years for this pension. Read your pension plan. It's in there, it has to be. Okay, well, we're right at 6:35. We've got about 10 minutes for questions and answers. What, do we have some questions?
I have a question, sir.
Go right ahead.
Thank you, Janie Castillo, St. Mary Center. At the beginning of the document, there was a question concerning bonding of executor. I don't understand what that means. Does that mean they don't get any money? They're doing it for free or something?
Bonding, did you say it?
If you look up to the top, the first page.
All right.
And then down a little bit, there it is. No bond or other security of any kind would be required of any executor appointed in this will. I don't know, what does that mean?
Well, bond is security. For instance, let's say most commonly, if you're doing a project and to ensure that you will finish the project, you're required to get a bond. Basically, I'm insurance, I should be able to give you a definition of this clearer. It is basically a guarantee that you're going to perform on what you say you're going to perform on. What they're saying here is a bond is not required. So one of the most popular in our property and casualty insurance business is you've hired a contractor to build a church, let's say, and he's giving you how much it's going to cost, data completion, and all of these different things. And to be sure that he does what he says he's going to do, you require him to get a bond. Now, for him to get a bond, he has to put up collateral to the insurance company equal to the value of that bond. So what this is saying is you're not requiring them to get a bond, a surety bond.
Okay,
Okay?
yes. Is it usually that executors get paid out of the estate? Is that a thing that has to be put in there?
It's statutory in the California law. Now, an executor can decline to get paid. Let's say it's your child or your sister or somebody, and they say, I don't want to get paid. Last week, we talked about what the executor and the probate attorney is entitled to, and it's a percentage base. On average, because the executor of your estate gets the same thing the probate attorney gets. And that can be 3 to 5% of the value of your estate. I actually have that on the other presentation. I don't want to pull it up now. But yes, the executor does get paid, but they can decide, oh, I'm going to do it for my friend for free. I would recommend that you guys not do that. You didn't hear that from me, but I don't care if it's your relative. Get paid because it's work. And sometimes you may not be able to go to work. So you deserve to be compensated. Especially, no offense, but especially when you're dealing with some of your relatives, you know?
And can I add a little bit? I work for the probate department, both in Alameda County and San Francisco, as a conservatorship investigator, and I have a coworker that's online as well. Bonds are required when you come to court, and it's like your insurance. You have to put down a certain amount when you're handling a probate. So the bonds are required when you come to court. And interestingly, I had a sister that passed away a while ago, and I didn't want to claim anything from her money and did not. I paid the attorney, but nothing came to me. And it's still in the probate process, but is almost complete.
How long ago was that? How long ago did that probate process start?
It started in early 2019.
Okay. But they can go years sometimes, especially if you have people contested it.
Yeah, this was not contested, but you know, I worked as a court investigator for 36 years, and we would see all kinds of people asking for payments and those not requesting payments. So, you know, it all varies.
It does.
Yeah.
Thank you for that.
Sure.
Go ahead, Keith.
Yeah. Hey, how you doing, Mr. Gaines?
Wonderful. Thank you.
Yeah, Keith Rivenwine, President of the Council of Elders of St. Mary's. I was interested in what you said about a parent having a kid that was over 18. For instance, if my son is 37. If he was in a hospital in a coma and he had a medical decision to be made, I couldn't make that decision for him.
Unless you got that document, brother.
So what is that document exactly?
That's the Advanced Medical Directive and the HIPAA form, because the HIPAA, I forget the acronym, it's actually an acronym, but it's a privacy act where they cannot share your medical information with anybody that doesn't have authorization, and that authorization is that HIPAA form.
And where would I get that?
Oh, you can get them anywhere. Are you a Kaiser member or any other health insurance?
Lifelong.
Huh?
Lifelong.
Yeah, just about every medical, you can get them online.
Okay.
But every hospital, every medical insurance company has a HIPAA form that you can enter into.
Okay.
Now, I'm a Kaiser member, and Kaiser has asked us to upload ours because they want it on file.
But wouldn't a next of kin be designated for him if he was incompetent, if he wasn't unconscious? Wouldn't they look for next of kin?
Well, I could quote back to a case we had a long time ago where this lady was on life support. I can't remember her name, and the family was fighting over who was going to make the decision of whether they were going to take her off of life support or not. So it could be a fight. It depends. There's not a one size fits all. Because if you're my sister and you say let's pull the plug, and I say no, we don't want to pull the plug, then guess what? We end up in court.
Can I also add, not only do your children need the healthcare directive, but we all need one.
Everybody needs one.
Everybody.
That's correct.
Mhm. And usually you can get it from your doctor. Your doctor has copies.
Your
And-
doctor wants you to have it. They want you to have it because they don't want to have to deal with your family if nobody wants to make the decision, if nobody agrees. That's just one less thing they've got to, one more thing they have to deal with if you don't have it. Any other questions? Okay, Antoinette.
Thank you, Jork, for an informative session. Could you take this questionnaire off?
Sure.
Thank you.
Forgot about that.
No problem.
You want me to put my contact info up?
That would be great. Also, if anyone has any suggestions on other Zoom information regarding estate planning or wills or anything dealing with finances and just need more hands-on, if you would email me, my email is in the chat. My email address is in the chat. And also, if you'd like a copy of this recorded session, which has everything that you've seen this evening during the session, will be in this recorded session. If you would email renewmag@gmail.com with your email address, a copy can be sent to you. So what we would like to do, we have one more session in November the 20th. And I do believe that Alameda County Care Alliance has confirmed that they'd like to come and talk about what they're doing in helping to eliminate abuse of people who are living at home with their families and need specific health care needs. So everyone will be receiving a notice regarding that date and time. I actually think it's from 12 to 1:15 on the 20th of November. And if there's any other information that you'd like to us to present regarding elder awareness, I do know that we're going to have at some point, I think it's going to be for in January. Well, we really haven't got the date yet. Shauna Gillespie made some indication that she worked for the probate court in San Francisco. And so we're planning on bringing some valuable information on how this system really works, just in case you end up having to go through that experience. It's good to have that information.
Hey, Antoinette, I'm sure Shauna would tell everybody probate is not something you want to go through. It's not a fun process. I see Ann nodding her head. Maybe she's been through it. And the older we get, the more likelihood that we're going to have to go through it. So I say, talk to your family. I know some people don't believe in it. They say stuff like, oh, we'll work it out. And it's just not true. So if you can have a family meeting and encourage everybody to get their advanced medical directive, to at least do a will. And especially if they're younger, they think, oh, I don't need it. But if they have kids, I had this happen back in the Loma Prieta earthquake. I'll say this real quick. I had a cousin, both he and they weren't married, he and his girlfriend were going fishing on the collapse, the pancake, and they had a 1-year-old, and they both were killed, and the 1-year-old was left behind. And the family was fighting over who was going to get the kid because the state was giving the kid $100,000. And it ended up in court for several years, and the kid was actually awarded to an uncle out in Modesto. So you never know. You just never know.
Right. So it's Jork and I have discussed how, for some reason, this is the most important thing that we could do for our families, for our children's future, is to do a will, a simple will, and get 2 witnesses at least and move forward. So we really are encouraging everyone to please do that. You don't know what's going to happen tomorrow, so it's a great idea to plan for the future now.
And Antoinette, you want to try to get a trust done because wills can be very costly. When my sister died, we didn't have anything pre-done, but we got a will created right before she passed away.
Mhm.
And the cost for the attorneys is, it's expensive.
Mhm.
So if you can avoid the cost of the probate court, cost of the attorneys, through creating a trust, that's my recommendation.
Mhm. Thank you.
Oh, Antoinette, if I may, give a little promo for Legacy Shield. Legacy Shield has a full-blown will with storage vault for all of your important documents, as well as pictures, videos, anything you can upload for $99. For the trust, if you're willing to do it online, complete the fill in the blanks. It's $500, $499, and you can even do that if you use an attorney. If it's a simple trust, they can set up your living trust with an attorney for $1,000, and you can do it on a payment plan, $50 a month for a year. Of course, if you do the math, you say that's $1,200, but that's the cost of doing it over a monthly amount. So you could actually use an attorney, $50 a month for 12 months and get the whole thing done. And I don't think you can find an attorney anywhere here in the Bay Area that'll do a trust for $1,000 or $1,200 if you do it on the payment plan. Excuse me.
Can you give the name again, please?
Well, I have a website. It's called Legacy Shield, but if you will send me an email or get to Antoinette and send it through, I will send you the link to my actual website. There's videos you can watch. And I say, just make sure you're going to do it, but with the attorney. That actually comes through us. So I will send you that link. I actually have a landing page because I get a small referral fee, but I want to show them that I'm actually promoting as well.
So in the chat, at the top of chat, it says, it gives Jorik's contact information. So it's
See real quick, you see my name? My name is Jorik.Gaines, and it is in the chat, but once we close this, the chat's gonna go away, so make note now. Oh yeah, there it is. That's my name, phone number. I see it right there. Amy Chu to everyone. That's my contact info. But it's the best value I've seen, but I do have, and that's because of that 100 attorney network, and it's all nationwide. It's not just to California. It's anybody anywhere, all 50 states. So if you got relatives outside of California, get them on there. I'll say one last thing about it. It has a very cool feature because you have to name your people in your trust and your will. They will get an email and they get the vault for free if you have them in your estate plan. Of course, the reason they do that, I'll tell you, it's business. They're hoping that they will also get a will or a trust, but they give them the vault so they can store all of their important stuff literally at no cost. So it's a great value. Feel free to call me. I'll be happy to talk to you about it. No pressure. You don't have to do it if you don't want to, but do something. You don't do that, do something, as Shauna would say. Do something. But the will also includes your medical directive, your HIPAA, your power of attorney, and the will. Okay. I'm done.
Thank you. Thank you.
You're very welcome. Thank you all for coming. We wouldn't be here if you weren't here. We really appreciate it.
Oh, I'm definitely going to make sure that all information that I have is given out to the community. That's what a Senior Advocacy Alliance is all about. So thank you
Absolutely.
all for coming.
Glad to know what you do. Really appreciate you.
Bye-bye, everyone. Good night.
Good night, everybody.